In this lesson, we will look at the role of the courts within the UK jurisdiction. Before we move on to the subject area or the topic proper, we must understand once again the certain divisions that we considered in the introduction to this course. I mentioned at the inception that you can divide law into so many different divisions, one of which is civil and criminal. While there are many differences between these two divisions, a primary distinction would be the fact that in terms of criminal cases that come before court, it is in fact brought before court by the state itself, whereas in civil matters it is between the individuals. As such, majority of cases must in fact be referred to court. And in fact, these matters are brought before court in order for court to provide a final determination, not a final settlement. It is important to note that the courts in the UK or the legal system itself is geared or catered towards an adversarial system. Now, what an adversarial system means in a nutshell is pretty much one person wins and one person loses. It's a battle between two parties where one party emerges victorious and another loses. There can be situations, as in alternative dispute resolution, where there is a compromise that occurs from both sides, but we'll not go into that at this juncture since it's an introduction. Now, if we look at very briefly how exactly a case progresses through the court infrastructure or the structure of courts in the UK, it begins at a lower court where the matter is heard and there is a determination provided. And an aggrieved party, a party who may have lost and feels that the decision was in error, could in fact appeal to a higher court. So this might mean a court of appeal or now the Supreme Court of the UK. In which case, if it is upheld, then there is no further redress to the claimant, to the person that has actually brought the appeal, or if the original first instance court's decision is opposed by a higher court, in which case the decision is overturned. So this is a very primitive method of actually considering the path that a case would take within the court infrastructure, but it's a good overview to understand. It is also very important to identify at the very inception certain definitions that we will be using throughout this course as well and throughout your studies, as well as examination situations. The first of which is what is called contempt of court. This primarily refers to when a party disobeys an order of the court or does not follow the determination of a court. What follows thereafter is in fact penal sanctions. Now, if you recall earlier, I mentioned that courts provide final determination and not final settlement. It might be the fact that a party refuses to settle from that point onwards, which means that an aggrieved party can come back to court where penal sanctions could be incurred on that party, on the opposing party rather. What could be considered as a quasi or pseudo court itself are arbitrators, which are much like courts and has a right to make determination, but in order to enforce an arbitration, you might have to go to court. It's a step below that of a court, but is privy to make determinations. The speciality of this is an arbitration usually occurs with the consent of two parties, that they wish to not go to court but actually have an arbitration beforehand. This can be heavily seen in terms of contractual arrangements where the two parties have contracted with each other with terms which are beneficial to both parties, and in the event that certain conditions or warranties are not fulfilled, they agree at the very inception of the contract to go into an arbitration. Consent orders is when both parties agree to come to a settlement by means of a court order. Ex parte is when one party is not present in court in terms of a case. You would notice when you study certain other subjects such as constitutional law or even contracts that certain case names have this term ex parte incorporated before a certain name. What this purely means is that one of the parties in question was absent or was not present in court and it was heard without said party. You heard me mention earlier about the UK jurisdiction, and what a jurisdiction very simply means is the right to hear and determine cases. Each court is vested with its own jurisdiction, and this can be either by case, either by the stage, the type, or the geographical area. So, for instance, Much like the divisions that we spoke of earlier, civil and criminal, certain courts of law have jurisdiction over all criminal cases, or only criminal cases for that matter, and certain courts have jurisdiction over civil matters only. Similarly, you have the original instance courts that I mentioned in the previous topic, as well as the appeals which come to the Court of Appeal or the Supreme Court, or at that time the House of Lords. Also, you have the geographical area divisions, which also limit the jurisdiction of courts of law, of certain courts of law. Now that we have briefly looked at the certain divisions and the structure of the courts itself, let's go in depth and identify the various groupings of the courts. The very first grouping that we have now briefly covered is civil versus criminal. Now, in terms of civil matters, it can be considered as private or public law. Private law refers to certain matters between individuals, such as tort law, family law, etc. Public law, on the other hand, which also comes under the purview of civil matters, would mean certain laws which are incurred between state and individual, such as tax law. Another grouping or division would be superior and inferior courts. One of the main criteria that define whether a court is superior or inferior is the duration of punishment or sentence that can be brought down by the court itself against an offender. So, for example, an inferior court might have the purview to punish an individual for 1 month on contempt plus proceedings, whereas a superior court for a similar charge of contempt might have the opportunity of sending an offender to jail for 2 years or more. Now, examples of superior courts are the Privy Council, Supreme Court, the Court of Appeal, Crown Courts, and High Court. Any court that has an appellate jurisdiction can be considered as being a superior court of law. And in considering appellate jurisdiction, another division that we considered during the inception of this particular topic is original versus appellate. Original courts are the courts which hear cases for the first time. Now, what's notable in terms of an original court is that evidence as well as facts of the matter are admitted to court at this particular jurisdiction, at this particular instance. Whereas an appellate court is one that hears appeals over an inferior court or an original court. There is no new evidence that is admitted, it must be noted, unless the bench or the panel of judges decides that it is of utmost importance to the case itself and there has been a material change in evidence or circumstances that warrants the inclusion or the admittance of new evidence. Now, it's very important to note that a good way to define both appeal courts and first instance courts or original courts is that appeal courts hear cases on matters of law, whether an original court has erred in its judgment in terms of the law implemented, in terms of legal proceedings. Now, the UK jurisdiction affords a tier infrastructure. What this means is, after the first instance decision is provided or is handed out, if an unsatisfied party wishes to appeal, they can do so to a higher tier. And it can go on and on until the final tier, which is currently the Supreme Court of the UK. That was a very brief overview of the various roles of the courts as well as the divisions or the groupings thereof. In the next lesson, we will consider the organization of courts by looking at the various types of courts which are in effect within the UK.